What do Elvis, Tom Carvel, Princess Diana, and B.B. King all have in common? Aside from being household names, they all made colossal mistakes in their estate planning that ended up costing their heirs millions of dollars in inheritance and attorney fees. You see, the twin burdens of fame and fortune don't make estate planning any easier. If anything, having all the money in the world only complicates things. But you don't have to be rich and famous to understand the importance of planning ahead. In fact, regardless of your net worth, every adult should understand the basics of estate planning and what areas are relevant to their unique situation. When most people think about estate planning, they think about wills, trusts, and where the money goes when they die, which, in a sense, is true. But estate planning is technically defined as the accumulation, preservation, and the ultimate distribution of wealth. So, if you look at it from that perspective, it becomes clear that there are other considerations that need to be addressed. First and foremost, it's important to have a clear disposition of assets that spells out exactly where you want everything to go. Otherwise, you end up leaving it to the courts to decide, like in the case of Princess Diana, who wrote a letter of wishes giving her mother and sister the ability to use their discretion whether or not to honor her wishes in her will. This, of course, caused a stir when her godchildren received a significantly less amount of money due to her mother and sister using their discretion. Oftentimes, families feud over the small things, such as jewelry or other specialty items that most would consider insignificant. You see, spelling out how you want your financial assets to be divided can simply be done through beneficiary designations on retirement accounts, like IRAs and 401ks, and for non-retirement accounts, such as checking and savings accounts. The equivalent of a beneficiary designation is called TOD, transfer on death. In other words, this is who is going to get this account when I'm gone. This is important because the accounts that you assign beneficiaries or TODs to can overrule what you say in your will. Which brings us to wills and probate. Probate comes from the Latin word probatum, which means something proved. The process of probate is to prove the legitimacy of the will that's being presented. The courts will first make available to the public a listing of all your assets, and since your assets are now a matter of public record, anyone can go to probate court and lay claim to those assets and essentially contest your will. Then it's up to the courts to decide if those claims are legitimate versus what the will states. As was the case of ice cream businessman Tom Carvel, whose passing launched one of the biggest legal battles in the history of New York probate law. The problem began when Tom and his wife left a will stating that their money should be put in a trust that would donate to charities and provide income for family members. The issue was the trusts were put under the control of two former employees of Carvel, whom the family members believed were responsible for his death. Whatever the truth, the case has been active for almost 25 years and still continues today. One way to avoid probate in a blanket fashion is the use of a living trust. But not everyone needs a living trust. As we described before, probate can typically be avoided through beneficiary designations. But if keeping your assets private is important to you, then yes, you should consider using a trust to avoid probate. But the real purpose of a trust is to be able to manage your money or other assets from the grave. So, for instance, if you have a child who you thought had marital problems or substance abuse problems, one way to restrict or monitor the use of those assets to ensure that they are being used properly is using a trust. Other considerations in estate planning have to do with power of attorney and making financial decisions if you become disabled, or if there are certain healthcare directives that you wish to have carried out in the event that you become incapacitated and can no longer communicate and make financial or healthcare decisions on your own, but you want to have your wishes known beforehand. This was especially helpful in the case of B.B. King, who in his final days couldn't make decisions on his own, and his children challenged his request to have his longtime manager handle his affairs through power of attorney. The courts quickly threw out the case, citing that his children were acting out of pure greed. We understand that every situation is unique and that things are always subject to change. As a matter of fact, the estate planning laws and thresholds themselves are constantly changing. For instance, currently the estate planning thresholds on the federal level for estate taxes are $10 million, $20 million for a couple, So more and more people don't have to worry about paying estate taxes on the federal level. However, some individual states actually have their state estate taxes kick in at as low as $1 million. So it's important to know what your state estate tax levels are as well. Just ask Elvis Presley, whose $10 million estate was forced to pay over 70% in taxes and fees when he died. By now, you probably have more questions than answers, but don't worry, you're not alone. We encourage you to visit our website to learn more about our upcoming estate planning workshops, or give us a call at the number provided, and we will be happy to schedule a free consultation.